Get a consent from you while we're
Sure.
recording. So yeah, that's what I was gonna say. Do you consent to your image, likeness, and anything
I do.
related?
I give you a non-exclusive license to use my image and any ramblings that I come up with.
No.
We should do that. We should do that on air. We'll do that. Do that on air.
No, you're fine. You're fine. This is all fair. No, that's good. That's good. That's good. This is going to be probably the biggest. This is the biggest and probably the biggest project I have ever done.
Ooh,
because
exciting.
because I've interviewed psychologists and also lawyers. So it's and now I'm interviewing an actual practicing lawyer in the UK. So
I think it'll be really good because I think
yeah.
you've been following this, and I think also you've got. I know, I mean, we all know what we think about the cases, but I think you've got a degree of objectivity that some people lack.
Oh wow! I did not. Thank you. I did not know. I did not. I did not think I communicated that well because it's obvious that I support that.
Yeah, but it's not. I mean, it's all about bringing the receipts. I always stay really neutral. I never comment about what I think on a case. I mean, I've done a video recently where it's one of the few times I've spoken about my personal views. That was that Just Stop Oil one, because I do a lot of talks for activists.
Yeah.
And I was saying about how I have to be careful not to cross the line into inciting them to do stuff. But I was saying, actually, I try to discourage people because I'm not a big fan of protest. I think it's it's the negatives outweigh the positives. And I actually used to warn people and say it's all right getting people up on this, but if they've got dodgy immigration status and they get deported, that's on you. And that's what's happened to this Marcus Decker guy. And I was saying, well, I did warn you. I did say this is exactly what would happen. So
So you are a lawyer, and
yes.
you're a lawyer. So what jurisdictions do you practice in?
Just England and Wales.
Okay.
I'm a member of the Bar of England and Wales. Of course, pre-Brexit, I could practice in 28 different jurisdictions.
Yeah,
Now, of course, I can practice in one. Because I used to do some stuff over in Ireland, which I really enjoyed, because it's similar enough that you can cope, but it's different enough to make it interesting. And also the bar culture over there is really interesting. It's a very different way of doing things there, but it's really nice. And I do a lot of international stuff. I do all the training. I do the advocacy training, but I also do some of that internationally. So I get to go to other countries and see how they do it there. So we'll go over and we'll train their local lawyers using our techniques, and then we'll sort of swap ideas, what works, what doesn't work, and we'll all feed back. And that's really interesting. Yeah, no, it's great because I just did something in China recently in Hong Kong, and they use a system that is ostensibly very like ours. But I know it's all the cliches about East Asian sort of pressure and culture and education. But I was joking with the guys. I said, there's that Simpsons episode where they go to Japan and it's like, in decadent West, you reward knowledge. Here, we punish ignorance. I was going, that's fucking you lot. That is just you lot, that. That's what you're like. And honestly, they were terrible. The poor kids over here were all... This is a very safe space and it's non-judgmental and just do your best. Don't try to impress us and we'll work through it. It's very much we will hold your hand to get you there. Whereas over there, it's like if you don't make the cut, we just don't let you qualify. And there are people who are actually practicing, but this is part of their compulsory further training. And if they don't, if they don't pass, they go, right, you're not allowed to practice anymore. It's really, really hard. But they get a lot of pressure. Yeah, because the judiciary over there, they were saying, if we let people pass who aren't up to scratch, the judiciary just come and say, this is a risk to the public, why are you passing these people? So, whereas over here, we sort of go, the market will sort it out. If they're not good enough, they just won't get instructed.
So, can you practice in China? Like, are you able to practice there?
I can, with a way, I'm not, some people are members of like the Hong Kong bar, and I have looked at basically doing that, but they sent me they said, there's a little test, you'll be fine, and they sent me all the past papers, and I was like, I can't understand any of the questions. But you can actually, a lot of English barristers do practice in Hong Kong on waivers for individual cases. So they can you can get a thing saying you can practice, in this, you can represent this one particular person in this one particular.
Oh, okay. It sounds like, what is it? I forgot what it's called, but they do the same thing in the States where you can go into a different state. I forgot the actual technical term for it.
I can't remember it either.
It's the worst time to forget that.
I know exactly what you're trying to say, and I can't remember it either.
Yeah, it's the worst time to forget. So it's actually very interesting that you brought up Brexit and how you were able to practice in 28 different countries, and now you can only do 28 different jurisdictions. Let me say it like that. And now you can only do 4. Like
I can do 1. I can do England and Wales. That's it.
Oh my flipping hell! Oh yeah, I'm thinking of Northern Ireland as well. I'm thinking of Northern Ireland. Northern Ireland, Scotland, England, and Wales. That's why I was thinking 4, but then technically that's 3 jurisdictions.
Scotland has its own. They have the Faculty of Advocates. And it is a very different legal system up there. It's very different.
Yeah. So
and in Northern Ireland they have quite a different-ish system.
Yeah. So which area of law do you do?
Now I mainly do media law, defamation, and animal rights. But I still do bits of bobs of all sorts of commercial stuff. But I started out doing crime and military, and then I ended up, my career, such as it is, has been a series of happy accidents. And I always have this thing of never saying. I always say yes to any opportunity. So when somebody said, "Do you want to cover a preliminary hearing at a court martial for me?" It's like, yeah, sure, and they bluffed my way through it, but I went, this is great, love it. And it was the same with the night lawyering. You've got to do it, because the worst that's going to happen is you'll confirm that isn't an area for you, but you never know that you might find an area that, A, you're really good at, and B, you really enjoy. So I say never paint yourself into a corner. You might be going, I definitely want to do this law, I definitely do. Good luck to you if that is what you really want to do. Great, and carry on with it. But always look at other avenues, because apart from anything else, you don't have to just overly specialize. I mean, now the bar is getting a lot more of a specialist profession. It's not like you just used to be common law barristers, where it's like, we'll just take any case on. What is it? Crime, civil, family? Yeah, no worries, we'll do it. That's changing a lot.
Yeah. I saw that you have a YouTube channel with Black Belt Barrister.
Yes.
Yeah. Who started that?
No, Dan.
Dan
started in the lockdown.
Okay.
He just started doing a channel, and it obviously really, really took off because he's very good. And I started with him just talking about defamation with all the Depp and Heard thing. And then I started doing more things with him, and apparently there was a demand. People said, you should do your own channel. So it's part of the sort of Black Belt Barrister brand, but it's like Dan just lets me, I just go off on my own little tangents and ramblings. So Dan does all his very professional, well thought out ones that are all really planned and really good and sort of, really professional presentation. And I just sort of go, right, what we're going to talk about tonight? Okay, here's something. And actually, but I like the fact that they are really spontaneous. I never rehearse them. I try to do all in one take unless I make a complete mistake. Or my usual thing is I'll do one in one take and then realise I don't have the microphone plugged in or something. So that happens a lot.
Yeah. So I gotta ask this question then, because you guys do have YouTube channels. Did you start your YouTube channel to spite Amber Heard?
No. I mean, Dan started his channel well before this, and he was talking about all sorts of things. But a lot of it, sometimes he comments on things that are in the news. Most of his channel is actually just useful advice for people. It's like, this is something you can use yourself. But actually, a lot of these celebrity cases, they provide a good jumping off point to discuss the law generally. But the thing with that particular case, and you probably noticed that every time I refer to it, it's like, that case, because it's the one that ever keeps coming back. I described it as the Jarndyce and Jarndyce of defamation, which can go down quite well. But first of all, people just misunderstood what defamation is and how court cases work, which is fine, because why should anybody know that? So it's an opportunity to say, right, this is what's going on, this is why people are doing that, this is the procedure. And also you could talk specifically about defamation, because it's quite a specialised area of law. I don't think it's a particularly complicated area of law.
Yeah.
I mean, I could teach you everything you need to know about defamation in an afternoon, but it's applying that law.
Absolutely.
Because when I did my night lawyer video, I was explaining that it's quite strange, because when you do a defamation case as litigation, you spend ages arguing about, is it defamatory, what's the meaning, all this sort of legal argument. But when you're doing night lawyering, you literally just look at an article and go, that's defamatory, that's not defamatory. You have to decide instantly.
So wait, I don't think I'm familiar with night lawyering, and I don't think my my audience is actually familiar with that term. What does night lawyering actually mean?
Well, at the risk of plugging one of my videos, a night lawyer is we are the people who are at the newspaper as it is being put together. So, and obviously that's done at night for the morning papers.
Yeah.
So, well, so I would go in there about 6:30, 6:30, 7 o'clock.
Yeah.
Check through sort of injunctions and DA notices and things. But then I would go to the news floor where all the sub-editors work, and as they were putting the paper together, I would basically sign off on all the stories and go, that's fine. Or sometimes go, might want to tweak that a bit, that's a bit dubious, etc., etc. So that's what you do as a night lawyer. You are basically making sure that the newspaper that goes out is okay for defamation, contempt of court, to a lesser extent copyright. Yeah. Copyright's not actually that big an issue in news, because there's no copyright in news. So long as you don't rip an article off word for word, then no, but people do that all the time. It's like such and such. The Mail's got an exclusive. Right, let's read that. Let's just change the words. So that's now our exclusive. They do that all the time. So, but. It's the fact you've got to be able to make an instant decision. Now, what's interesting is, with the Depp and Heard thing, the article in The Sun, had that have come to me, I would have actually suggested some changes to it. I would have said, actually, you might just want to tweak that and tweak that. And what's interesting is, those changes were made to the article.
Oh.
But only for the later editions of the newspapers. So one edition of the newspaper went out with the article phrased in a particular way. Then it got changed. But Depp was allowed to sue on the first version of the article.
Oh, okay.
Now, had he have been successful, that probably would have gone to damages, because they would have argued and said, well, look, okay, that was defamatory. However, that particular version of the article was only in the first batch of newspapers, so the audience it reached wasn't the full audience of The Sun. It was just it was a small subset of people who got the first editions. And the way it actually works is the first editions go out to the sticks because they've got further to go. So you'll get ones in central London and people will start reading those straight away. But most of them, they go on trains up to sort of Newcastle, because they've got to get further afield. So the bulk of readers will have read the non-defamatory version of the article. So the argument would have been, well, the damages have to be reduced because because that's one of the factors that goes into defamation damages, is how many people saw this.
So sorry. Continue. I'll ask the question afterwards. Sorry about that.
No, it's just that's it. It's how many people saw how many people saw the offending statement or heard the offending statement or the offending article. That's not always the case. There could be something that is only relayed to one or two people, but it's highly defamatory. Say, for instance, the only person who hears about it is your bank manager, and you get refused a loan because of it. Then, even though publication wasn't very wide, it has a big effect.
Count as damage.
But
yeah.
One little tip for people. This is an old defamation lawyer tip, because obviously the wider the readership, the more serious the defamation, the bigger the damages. Mm-hmm. Newspapers always argue that nobody saw it. So what you do is, before you contact their advertising department and you say, I am thinking of putting an advert in your newspaper on whatever page the article appeared on, of this size. I'm going to put an article. How many people will see this? And of course, the advertising department always say, oh, loads of people. we sell 100,000 editions, and every edition is read by 97 people. And you go, can you put that in an email for me, please? And then they do. And then when they're going, nobody sees this, you go, well, that's not what your advertising department said. I mean, judges are pretty wise to that now, so they do take that into allowance. But that's always been an old defamation lawyer's trick, that is to speak to the advertising or marketing department first.
That is such an interesting parallel, because when I used to DJ, funny enough, this was always my negotiation when I was trying to negotiate, my my wages for the night. What I would always be like they'll always start with the lowest point, and the first question I would always ask is, how many guests do you like? Let's be honest. How many guests do you guys actually get here on an average night? They will tell me, I'm like, my wages should match how much you're making on the bar spend for this night, because they're gonna have to, like, they can't say, oh, we don't get that many, because that means, well, I'm gonna walk then. I'm not gonna play to an empty club. You know what I mean? So it's actually very interesting that that's the actual that's something that you guys actually use to get around that and get the info to actually be like, hey, your marketing department says this.
Yeah, but you'll know that, because I used to work in the music business, used to tour manage, and you'd always have that, because obviously a lot of the time the fee for the group was based, it was like a fixed fee, plus then depending on how many people came, you got a percentage of any people who attended over a certain number, and it
plus guest list.
Yeah, exactly. Yeah. Well, that's why I always used to say to people, it actually costs us money to put you on the guest list.
The UK's defamation and the laws, the civil rules around defamation, etc. How many cases do you think? I don't know the amount. How many cases do you think gets adjudicated here, versus the number of lawyers that are here?
Hardly any. I mean, most civil litigation in England and Wales settles anyway. 97% of issued claims settle before going to trial.
Ouch.
Because of our system, which is very front-loaded, it's very early disclosure, very early exchange of witness statements. And if you've got decent lawyers, we can all look at that and go, well, we all know what's going to happen here. Yeah. So we can predict in advance. So it's probably just a couple of dozen defamation cases actually get to trial every year. I mean, some get there because the other side just will not cooperate or defend or anything, so they go through. With defamation, unlike, say, just a straight money claim, even if you get judgment in default, in other words, the other side didn't even bother defending it, so you win automatically, there still has to be a hearing to prove that damages. Whereas, if I just sue you and say, you owe me some money, and you don't defend it, I just get a piece of paper going, you owe me the money, and I send it to the bailiffs. If, however, I say you defame me and you just don't cooperate, and I get the bit of paper going, yes, he's not defended this, so he's defamed, I still have to have a hearing and say, and these are the consequences, and this is why I should get this amount of money. So it's not as automatic as with some some other types of civil litigation. But
sorry, go on.
No, just saying, but it's very rare for a defamation case to get all the way to trial, not least because they are stupidly expensive. And you've got also with defamation. I mean, my advice in defamation is always never sue. I don't care how strong your case is or how badly you've been hurt. It's very rare.
Why do you have that advice? I must ask. Sorry to cut that.
No, because the thing in defamation is all your dirty laundry is going to be washed in public, and there's always going to be some people who go, "Well, I still think it was true. I don't care what the decision was." So, it's a very messy, dirty business. I mean, all litigation is harrowing and horrible and time-consuming and stressful, but having your entire life forensically dissected to show what a terrible person you are, it's not fun. So you can see why people try and avoid it. And I mean, now we have the serious harm test in defamation. Now, I mean, pre-2013, so libel, written defamation or permanent defamation, was believed to be actionable per se. You didn't actually have to show any specific loss. It was just, yes, you will get damages just because of the seriousness of the allegation. Now you've actually got to show serious harm. And if you're a business entity, it's serious financial harm. So you only really bring a defamation claim now if on cost-benefit analysis, not bringing it is the worst-case option.
I get
You know, it's like, if I don't bring this, I'll never work again, something like that. So I've got nothing to lose. But just, you know, because you've got hurt feelings or a few people dislike you, it's never worth the hassle, because very few defamation cases change people's minds. People usually have their own assessment of the people involved, assuming they know anybody.
Yeah,
I mean,
I get that. Yeah.
Yeah, I mean, that has actually been, you know, there have been a few defamation cases, especially with social media or local councils, where hardly anybody's heard of it. And there was one where they literally said, everybody who heard this, it was so factionalized because it was like a local council.
Yeah.
They said, basically, everybody who likes you wouldn't believe anything that was said about you anyway, and everybody who doesn't like you thinks that, you know, already thinks you're the worst person in the world anyway. So it's pointless having a defamation trial, because you will get no benefit from this whatsoever, because you'll get your bit of going, I was defamed, and all your supporters will go, well, we knew that anyway, and all the people who hate you'll go, I don't care. so you know,
that's a very interesting context I use. I think you said serious harm, which was I think my friend's a friend of mine that is I believe she does contracts and tribunals. I think that's what she said to me. I'm butchering it hard, but the point was she actually did. She brought this up and said that it was akin to the actual malice. Is akin to the actual malice standard in the US, where you gotta prove that the person was actually in their mens rea, that they were actually intentionally going out to sell a lie, basically. So
we have malice as a concept in English defamation.
Yeah,
it's slightly different because we don't have this distinction between public figures and private figures.
Yeah,
we have a distinction between public bodies cannot sue for defamation, but unlike in the US, individual people on a public body, like individual politicians, can sue, and there's generally speaking, there's no malice requirement. But we get malice where certain situations are described as attracting what they call qualified privilege, and the classic example is a job reference.
Yeah,
because if you either have a duty to impart the information, or the person has a legitimate interest in receiving this information, which obviously a new employer and an old employer, that can't count, then it's only defamatory if it is the mistake is malicious. In other words, either deliberate or you didn't do your due diligence.
Yeah.
So that comes in there. So we do have qualified privilege, and to defeat qualified privilege, you have to show malice. But we don't have a general malice requirement.
Yeah.
We're doing what we call malicious falsehood. Malicious falsehood is another species of defamation where the allegation doesn't actually have to be derogatory. It doesn't have to lower people's estimation. It just has to be untrue and cost you. So, as the name suggests, malicious falsehood. You can't accidentally maliciously falsehood somebody. You have to do it deliberately or be reckless.
Yeah, this is going to be one hell of a technical interview, by the way. Just putting it out there. Just putting it out there. You also said earlier that in terms of what people, unless people pursuing defamation, they're always dissuaded from it, saying that it's basically pointless. If someone likes you, they're not going to believe it. If someone hates you, they're not going to believe it. Do you think that is the intensity that Depp was pushing for the UK case? Do you think that kind of more or less showed how much he really wanted to prove that this really didn't happen because of how it was widely believed and still believed?
Yeah, well, we saw from the US, because a lot of the evidence was about loss.
Yeah.
Because he was suing for what we call, special damages. You've got your general damages for your hurt reputation, but special damages are, here's a quantifiable loss because I have lost work because of this. Yeah. And there was a lot of time spent on that. And, we all know that, he was losing film roles and had been taken out. So, presumably he took a financial decision and he said, he will have been advised as to how difficult it is to succeed in a defamation claim, as demonstrated in the London trial. But he must have, done the cost-benefit analysis. Said, well, it's all or nothing. I'm pretty much unemployable at the moment. Therefore, what have I got to lose?
That's interesting. Sorry. What have I got to lose by bringing? Continue. I'm very, very sorry. Like I guess I get ahead of myself sometimes. Sorry. Go on.
No, but that's it. But sometimes you see people. It's like, yeah, that was horrible. It hurt you. You've had a bit of a setback, but it's not completely derailed your life. So, as we say, today's headlines are tomorrow's fish and chip wrappings. News is perishable, and eventually nobody cares.
Yeah.
People forget stuff. I mean, we can all look at people who've done something something horrible in their life, but they've kept their head down for a bit. They've made some sort of half-hearted apology, and they're back on the circuit in a year or two. Like your Louis C.K.'s and people like that. So it's not necessarily career-ending. I mean, look at Mel Gibson. Mel Gibson's still got a career, and he's certainly a colourful character, as they'd probably describe him in the press. But yeah, I mean, you've really got to make that sort of financial calculation. I would say never sue anybody just because you've got hurt feelings or you're upset. Only sue them if this is actually costing you serious, real money.
Sorry. Continue. And it's I think you're gonna say, and it's.
No, that's it. It's just. I mean, we always say this about any litigation. You've got to really think hard. Is it worth pursuing? Because even in like just bog standard financial litigation, because of the way costs work, and you never recover all your costs, even if you win.
Is there much difference between, because we've seen both cases bring both different results in regards to this, and we're looking at two systems here.
The one thing that I think people need to understand is no judge is required to come to an objectively correct decision. Their only obligation is to come to a reasonable decision that a reasonable person could have come to on the evidence available. It's not uncommon for appeal courts to go, actually, we might have come to a different view. Mm-hmm. However, unless the judge's view is one that no reasonable person could have come to, it's unappealable. So the mere fact that lots of other people go, well, actually, we'd have probably gone the other way, that's completely irrelevant. But the idea with the jury is it sort of averages out, because you've either got 7 people or 12 people. And, they're a gestalt entity. So the idea is that, you get a mix of views and a mix of personalities, and they'll probably collectively arrive at a better truth than a judge would.
That's
because one person on one particular day, they can pretty much think anything they want. And like I said, that's something that I find very hard to understand, is that it's something, lawyers, we have this concept called Wednesbury unreasonableness, which is it's only unreasonable if nobody could have come to that decision. And the mere fact that different people, the idea is that, different people can reasonably come to different conclusions on the same evidence. That's all we're saying. So, that's your luck of the draw with a judge.
So I got to ask then, in terms of the law, because in the States that they have the actual Malice standard as well as substantive truth, and then I think you mentioned earlier that you were saying, alluding to beyond a reasonable doubt. I know that you were referring, that's obviously only a standard applicable in criminal law, but in terms of the actual Malice standard and the substantial truth being available in the States, and we have over here serious harm and substantial truth, do you think that when you actually factor in the weight of these standards, do you think that would be enough to say that this is closer to a reasonable doubt standard, or this is closer, or they're both kind of playing on the same playing field?
It's a similar thing. I mean, the classic example is the O.J. Simpson trial.
Yeah.
O.J. Simpson in the criminal trial didn't do it. In the civil trial, he did do it.
Yep. Because
it was different standard of proof.
Yeah.
So we can't say. I mean, actually, I must confess, I watched that trial, and I think that was the only decision the jury could have come to. It was such a terribly prosecuted. It was a man not to prosecute a case, whereas the civil things apparently were conducted a lot better. And the fact of the matter is, in the same way, I mean, courts try to avoid having inconsistent verdicts by saying you can only bring one case once in one jurisdiction. And that was what all the res judicata argument was in you, where they said, well, look, there's already been a trial in the UK, but it only applies if it's between the same parties. And because Amber Heard had specifically excluded herself from being a party in the UK trial, I keep saying UK, it's England and Wales, then they said it's not the same parties, so res judicata doesn't apply. And I have done a couple of videos on this on our channel about, the very technical aspects of this, about whether you can sue again and what jurisdictions you can sue in and whether you can raise new arguments or whether people are bound by previous decisions. But yeah, I mean, I'm a big fan of juries, certainly in criminal cases, because I just think collectively people are smart.
Absolutely.
And I have a lot of, I think, and also people just have better real world experience, because a judge by definition can only have one person's life experience, their own. Yeah. Whereas a jury brings 7 or 12 people's life experiences to the table. And I just think they're in a much better position to assess matters of fact. Just because they spent all their life doing that. We spend all our time going, do we believe somebody, do we not believe somebody? That's how you get through life, isn't it? And collectively, people tend, I think, to come to good decisions. I mean, it's not uncommon to say, well, actually, on that evidence, it could have gone either way. I mean, we quite often say that. Had a jury convicted or acquitted, had a jury found somebody liable or not liable, any of those decisions were reasonable.
So I got to ask then, do you think the judge made an error? I mean, by not allowing Amber Heard to be part of the defense and open up to discovery. The reason why I asked that is because I always look back on this and I'm like, I can understand the position that the judge was in when he got the Judge Nichols got the application for Amber Heard, because he was in his head, I'm pretty sure he was thinking, she didn't write this, she was not a co-writer, she was not even mentioned. Well, she was mentioned.
Well, the fact of the matter is, had they have wanted disclosure against Amber Heard, they could have chosen to sue Amber Heard, and then she would have been a part. So that was a tactical decision on behalf of Depp's lawyers, not to sue her.
Could they have sued? I mean, she wasn't really. How could they have sued her if the Sun and Dan Wootton were the Sun publication, Dan Wootton writer? How could they have sued her?
Because she was the author of the original statement. So.
Oh wait, that's allowed here?
Well, yeah, because that's the standard thing. I mean, usually you sue a newspaper because they've got the money, but you can sue the person who. So, say somebody is in a newspaper article and they say defamatory about you. You can sue them directly because they have disclosed to a third party, i.e. the newspaper, and through the newspaper, the entire world. So you can choose to sue the person who actually, is the person who made the statement originally. So
switching gears a little bit, because I want to talk about how both systems handled this case. I've noticed that the UK system it's very close to the police. It's very close to how the police does things. You take a statement and you write down all of the things that happen as you remember it, as everything. You make it right there and there. Where the US is like, nope, you come in here, sit down, and you tell us everything in front of everyone. So in terms of both of those approaches to doing this, and obviously allowing revisions and updates to witness statements, how do I ask this? There's a way I want to ask this without making one system looks better than the other, or this and that. But I want
different systems over here in civil proceedings. Now, we don't have examination in chief generally, or direct examination, as our American friends would say. So it's all done on a witness statement. So each person produces a witness statement, which is served on the other side very early on. And they go into the witness box, and their own lawyer says, could you turn to page 300 in the bundle? Yes. Is that your statement? Yes. Could you move forward 20 pages? Is that your signature? Yes. Do you adopt this statement as your evidence? Yes. Please wait there. There may be some further questions. And then cross-examination takes in.
Starts.
Whereas Yeah, whereas in the US,
Yeah.
I mean, you give your evidence in chief orally. It's like your own lawyer goes in there and teases your version of events out. So that's a major difference. But we just do it purely for convenience. It just speeds things up.
My friend told me, the one that works at the tribunal, she told me that we have an open court system here, open public court system. Yeah. So what does that mean for the layman like myself? What does that mean?
Generally speaking, most court hearings, unless they're to do with sort of certain family proceedings and some things where financial matters are discussed, like corporate stuff, they're generally they're open to the public, so anybody can go in, sit there, and watch the trial.
Right.
We don't have televised trials, obviously, here. We're experimenting a little bit with televising appeal court stuff and sentencing decisions. But yeah, generally speaking, anybody can go watch a trial. And generally speaking, you can report on anything you hear, subject to certain reporting restrictions, you can't necessarily name minors. You can't necessarily, certain elements of the evidence they might say, we don't want you talking about this outside. But yeah, anybody can do that. You don't have to be a journalist. Journalists have always been allowed into family proceedings, even though members of the public aren't, because they are trusted to know what they are and aren't allowed to report. But yeah, justice must not only be done, it must be seen to be done. So the starting point here is all cases should be open to the public. I've just done a video actually recently, in the last 48 hours, I lose track, which was about public interest immunity certificates here, where sometimes trials have been heard, what we call in camera, where the public haven't been allowed in because of like national security implications and things like that. But generally speaking, although we don't televise trials, anybody can attend a trial and anybody can report on a trial. And one thing we do allow now is live tweeting from trials, which we never use. So long as you're quiet and discreet about it.
I think, I think, who said that? There was someone, because of the post office scandal, that's why it was allowed. Someone said that to me.
Because
that's how Nick Wallace was able to, because he was really, him and this other guy, because I was speaking to him, I forgot his name. I apologize if you're watching this, but he basically said that that's how it came about, because I do remember Nick being part. He said Nick was part of it, and he was part of it, and after that case, he was allowed to live tweet. Nick was the pioneer of that. So so that's why we were able to get
because
from there.
Theoretically, you could have sort of sat in court and run outside every 2 minutes to tell one of your friends to bring the newspaper and tell them. So rather than doing that and annoying everybody, so long as you are quiet and you're not disturbing anybody, you can tweet, you can make notes. I mean, what we don't like is loads of people there clacking on keyboards, because it's just No, it is. It's because fundamentally, it's all about what interests of justice. And while there is obviously a public interest in knowing what's going on, there's more of a public interest in people being able to, give their evidence without being distracted.
I might start doing this, to cover UK cases. I might actually start doing this. I didn't even know that. Well, I knew the live tweeting part, but I didn't know it was that easy to, just walk in and, do it.
Yeah.
But
it's also, because you always tell the law students this. I'll say, go to court, find the usher, because the ushers are the most important people in the court system anyway, and just say, I'm a law student, or I'm just somebody who's interested. I just want to come down. And they'll tell you, they'll say, oh, well, there's a good case about to start in court number 3, or what you should do is go, they're really nice about telling you what the interesting stuff is. Because one thing you will notice if you ever go to a real trial is just how tedious it can be. There's like 10% of it is like, wow, this is interesting and relevant, and 90% of it is sort of, we just have some housekeeping matters to deal with.
So the reason why I asked that question is because Amber Heard was actually allowed to come in and sit down and hear all the witnesses.
That's very in civil cases. Generally speaking, in criminal cases, people wait outside until they've given their evidence. But in civil cases, the parties are allowed to be in court, and it doesn't really matter.
She wasn't party. She was.
Yes. Sorry, not a party. But in civil cases, we don't keep the witnesses outside because, apart from anything else, everybody's putting witness statements. So it's a lot harder to tailor your evidence. Because let's say you're in there, and go, oh, that person said this, right? I need to tweak my evidence. Well, it's too late. Statement's already in there.
Yeah.
So you'd have to sort of say, oh, I've just remembered, notwithstanding what I put in my statement, now this is what actually happened.
Yeah.
So there's no real risk of prejudice. But even before we did witness statements, people have always been allowed to sit in civil trials, regardless of the fact they're about to be. So you can apply to a judge and say, I want this witness to be kept outside. The judge might say, well, why? Well, I don't want them to pay their evidence listening to everybody else. But the judge will say, well, it doesn't matter because they've got witness statements in. And you could put, they say, if you're saying there's a previous inconsistent statement, you can put that to them. But sometimes you might be able to persuade a judge and say, look, can we just have everybody outside just while we deal with this bit of the evidence?
Okay. Oh, okay. So it wasn't necessarily a violation that she was actually allowed to sit in. And
no, it was a no.
Oh yeah, because I know is in the US, like it's actually you can't do that. Like if you're a witness testifying, even if you're a party or whatever, you can't actually sit down in the same courtroom until you are finished testifying. And I found that very interesting. That she was allowed to do that, and in the US it could never happen.
You can sort of see the logic in that you don't want people tailoring their evidence based on what everybody else has said, but at the same time, the risk of prejudice is relatively low. I mean, they do a thing here when they have expert witnesses now. They call it hot tubbing, where they have them all there and they just go around. They don't have them giving evidence one at a time. They just sort of go around, have them chatting with each other and say, well, what do you say about this? What do you say about this? Maybe we should do that for all witnesses and just, right, instead of calling you in order, you go first. Now, what do you say about that? Okay, well, what do you say?
I'll just copy your homework.
Yeah.
Okay. So, in regards to Judge, did you have a chance to examine the Amber Heard and Johnny Depp's witness statement as well as the cross-examination and redirect? Did you look into that side of the case?
Well, the English trial or the US one?
The UK one. I'm sorry.
No. I mean, all I've done, to be honest, all I've done with that is because it's quite a while ago before I sort of doing YouTube things. Obviously, because I do defamation, I read all the judgments. I read the judgment and the appeal document, the appeal things and stuff. I haven't had sight of any of the original papers other than the ones that are referred to in the judgments. So, to be perfectly frank, it's not something, so sometimes it's interesting seeing. I'm more interested in seeing other people's legal arguments rather than statements because there might be something in there I can steal. So I like to see copies like the pleadings and the skeleton arguments, just because it's like, well, hang on, how are they arguing this point? I might be able to, I actually do that with some people in other cases. I say, can you send me a copy of your skeleton argument? I deal it in like Apple Pages format.
I see you're like me.
PDF. Oh, don't send me the PDF because then I can't just cut and paste it.
I can relate to that so much. So did you? Okay. So were you? The judge decided to keep out some audio tapes, and in my opinion, and this is just my opinion only, I think this was where the case hinged because the audio tapes didn't come in where you can have Amber Heard cross-examine. That said, the judge did actually hear it to obviously decide, to keep it out or not. So how much of an impact did he keeping or barring certain types of evidence, how much of an impact did that have in the case in the UK compared to the US case where most evidence made it in outside of hearsay?
I don't know. You see, I mean, basically, the judge took a view and said, as judges quite often do, and said, you know what, forget everything. I'm just going to look at these witnesses. Who's coming across? Who do I believe?
Yeah.
Now, judges are given very specific guidance about demeanour, and the mere fact that a witness is very confident and very consistent doesn't mean they're telling the truth, in the same way that a witness who's all nervous and shambolic doesn't mean they're lying. So, they don't just do it on demeanour. But judges are they consider themselves very good at being, sort of assessing where the truth lay. Now, we are often told there's a thing called this is getting really technical, something called the Guestmin principles. Guestmin, if you want to look that up, which is, oral people giving evidence is great, but human memory is fallible. It's reconstruction, it's not recall.
Yeah.
Your point should be, let's have a look at the documents. Let's have a look at the stuff that is, less subjective. And especially documents from before anybody knew there was going to be a row. Documents, this happens more in commercial litigation, but emails and documents and letters that were done before people knew there was going to be a big fallout in litigation tend to be quite, it's like, well, hang on a minute, this is probably what really was going on, because nobody had any reason to not be telling the truth at this stage. But yeah, I mean, the judge sort of said, well, I find this is more credible, and I find this is true, and I find, she was quite compelling, and perfectly entitled to do that. And in terms of what evidence went in and what evidence went out, it doesn't really matter that judges hear evidence that they later exclude or don't rely on. Judges are really good at the mental gymnastics there. I mean, you get this in criminal cases a lot. I've had judges where I've chatted about this in another video where we're saying about they were trying. There was a public interest immunity thing to keep out the fact that our guys had been under observation. Every single one of their conversations had been recorded because they were being booked. But we were actually quite glad it didn't go in, because they were basically admitting the entire conspiracy. But because they didn't want their secret sources revealed, it was like, no, we don't want this in. But the fact of the matter is, the judge knows. Our guys are standing in the witness box swearing that they know nothing about it. A big fit up, and the judge was perfectly nice and put that case to the jury perfectly, even though the judge has heard all the tapes, where they've just admitted everything. So judges are very good at going like, well, it doesn't really matter. It's like, to quote A Few Good Men, it doesn't matter what you believe, it's what you can prove.
Yeah, you can't handle the truth.
Can't handle it. Look, I've done a courts martial, and I have to tell you, they're a lot more, they're a bit more restrained than that. And also, they're not in quite as nice a courtroom. I know every court-martial lawyer I was chatting to, including all the ones in the US, was going, that's a bit posh, because normally we just do these in like Nissan huts. We usually just do this in typical army buildings, and they don't look like that.
Okay, so there is. How do I ask this question? So now we talked about parties. She wasn't a party in this case, but she was a party in Virginia. How much do you think did that have that much impact? Because again, this was a talking point. Did that really have that much impact in regards to how this case was actually decided? That she was a party in the US and wasn't a party in the UK.
I think because Brown Rudnick's technique was to use Amber Heard's own words against her and own evidence against her. I mean, it's a very safe way of doing that, which is like, well, you said that. You're now saying this, but here's something where you said this. You're now saying this, but here's this. I just think they had more material to work with. I think, like I say, the English lawyers perhaps had their hands tied behind their back a little bit without the disclosure. It was literally just one person saying something with nothing to rebut the saying. Yeah. I think that certainly assisted them. I mean, like I say, both Heard and Depp's legal teams in the English trial were brilliant. They're really, really high.
Sherborne is the most decorated lawyer here. Like, I was surprised he lost. If I'm being honest with you, I was really surprised.
Yeah, I mean, but you just never know. This is like, litigation is risky. I mean, I would advise Depp not to sue in England and Wales unless it was absolutely, you've nothing to lose by suing. I would have said, if it's a situation where even if you lose, it hasn't made it any worse, well, you may as well. But I would have said, but having said that, I would have said you're going to lose this, but I would have said you're going to lose it on the public interest, which they didn't even run in the end. So that shows how. But, I would have said you would have lost on you'd have lost on a defence they didn't even run. Yeah. It really surprised me they didn't run that defence, because they didn't even raise it. Very weak.
Like, how do you so? Because they didn't run that defense, how strong do you think it is how meritorious is the judgment that came down that said that that the case was dismissed based on the defense that they ran in terms of substantive truth?
What always hurts a claimant when you get knocked back is that the judge did find, there were 14 allegations and he found 12 of them, but the fact that he said 2 of them I don't find credible. You can't really say he was biased or he wasn't applying all the relevant tests. That's the same thing in the Virginia trial. mixed verdicts are always really hard to appeal. So
Yeah.
the one thing that would have scuppered any appeal of Amber Heard, apart from some very technical stuff and all that sort of Newsom case and all that sort of stuff that we discussed at length, the fact that there was a mixed verdict where they found in favour of her on one of the counterclaims, because then it's like, well, you can't say the jury didn't look at this evidence carefully, and you can't say they were biased, because they actually applied the test properly, and some things they found true and some things they didn't find true. So they clearly weren't doing a broad brush or just going with who do we like.
Absolutely.
They clearly and made an assessment on the evidence.
Yeah, if we can talk about that for a second, I do. That's why I'm like, the way that the jury is getting targeted in this case is
I hear that.
It's stupidly unfair, because I'm like, if you look at the case that at the statement that they even rule for Amber Heard, like, anyone would look at that and be like, of course they would rule that way. It's so loaded.
People having digs at juries, because being a juror, jurors take their role very, very seriously, in my thing, and it's a thankless task. I mean, okay, you might want to be on a celebrity case, but nobody wants to be on a case for 6 weeks.
Now, I will say this for a fact. I will say, I think you already know this, but this is something that I found out today. My brother just got called for jury duty, and he doesn't know the case he's working on. He's just told, go and work there. So like, even just that little part, like, there is no way for you to actually know, yo, I'm gonna get Depp's case, because I think even there was some lawyers in VA that was saying that there was literally other cases happening, in the other rooms.
I mean, obviously they have questionnaire. They do more voir dire's of jurors in there. So you do know that, when they do jury selection, it's like, this is the case that you then know what the case is about. Whereas here, where it's just like first 12 out of the hat, sit in that box. Yeah. But I mean, until you get to the court, you've no idea. So presumably, it's not like you go, oh, I'm going to be on this really famous high-profile trial. Like, oh, I'm self-employed and working that week. I have a dental appointment. How people desperately try to get out of jury service. It's very interesting. In Roman law, they did a thing where anybody who was eligible not to be on a jury, who still volunteered to be on a jury, they would disqualify them anyway, on the grounds that the only reason anybody who didn't have to be on a jury wanted to be on a jury is they were taking bribes. So it's like, if you didn't use your exemption, they said, well, we're not going to have you anyway.
Yeah. That has been the one narrative, and I'm just trying to, like, I don't understand. Well, I do understand, because sore losers would obviously blame a bad workman blames the tools.
Jury. I think that's really unfair, because jury, they have a thankless task. It's horrible. You lose loads of money being on a jury, because you never get anywhere near what you lost wages or anything. It's boring. It's as dull as ditch water. And then at the end of the day, you just get slated for your decision. And it annoys me here. I mean, over here, jurors are anonymous and they can't be questioned and stuff. So it's easy to put their head down. But it really bugs me when you get commentators sort of in the media saying, "Oh, this jury got it wrong." It's like, well, you weren't there. You did not like hours of this.
Yeah, you're very rich saying that from there.
I mean, the one thing that made me think this jury really paid attention was, at the time the judge was giving her jury directions, she made a mistake, which I actually tweeted and said, oh, she's slipped up there. I wonder if this will be relevant later. She gave the wrong direction on filling the form out. And when they came back and they hadn't filled out page 3, I said, I told you that would happen.
Oh my gosh. So that's why people were blaming them for that. It wasn't even their fault.
No, she just made a slip of the tongue, because she said, and if of course you find for Mr. Depp on all 3, then you leave this blank. And what she meant to say was, and if of course you find against Mr. Depp on all 3, you leave this blank. And I said that at the time. I said she slipped up there. I wonder if anybody will comment on that. I'm very surprised, actually, the lawyers didn't pick up on it and say, can you just clarify?
Oh my gosh. Oh wow, great year. So because of that is why the jury got out and came back without the form being filled out, and they had to go back in.
The judge had told them to do that. She took them through very carefully. She said, if you find for Mr. Depp on count 1, blah, blah, fill that ball and then go to this page and put that where you put the number in. If you find on 2, then do this. If you find on 3. But then at the end, she said, but of course, if you find for Mr. Depp on all 3, then you leave this blank. And she meant to say, if you find against Mr. Depp on all 3, you leave it blank.
Oh, my heavens. Oh, great ear. Because for so long they've been lambasting. Well, they being the Amber Heard supporters, they still exist. So they've been saying that the jury was so incompetent that they couldn't fill out the forms. Well, now we know why. Because
I think that was a sign that they were hyper confident because they picked up on something that none of the lawyers did. I mean, lawyers should be watching out for stuff like this.
Oh,
because,
my gosh!
You know,
they actually went back and said, "Could you please?"
Because the one time you do try to stay awake in a jury trial is when the judge is giving the directions to the jury, because you want to make sure they don't tell them something wrong. Because, you know, it's like, you know, if they just make a slip of the tongue, you've got to be really careful there. Because, you know, jurors are smart. Jurors are very smart.
Yeah. I'm glad that you brought that out. I'm really happy you brought that out. I was going to say, so watching this case from a UK and knowing that, you know, that he lost in the UK, what was your thinking going into this? Did you think he was going to have an easier ride?
No, I thought it was stuffed. I thought it was going to lose, especially in the US, where you've got much higher First Amendment rights and also proving malice. You know, it's a much harder hurdle. But what was very interesting is, I mean, no disrespect to Brown Rudnick, who are very good lawyers, but you don't win cases by being good. You lose cases by making mistakes. So minimize the opportunity to make the mistakes. And that's what Brown Rudnick were very good at. They were very conservative approach. They played it very, very safe. They were like a model of not risk taking. Yeah. Whereas it really surprised, and no disrespect to Elaine or anything like that, because, you know, lawyering is very, very hard. I would never criticize another lawyer because, you know, if somebody was to show my my highlight reel of all my cock-ups, it'd be like, oh, you know, I do, because the good thing about this, I can use all my, when we train up the new barristers, we always actually have a thing where we tell them all our own mistakes. Because it's like, look, you know, this is how hard it is. And also, you can learn from all the cock-ups we've made. We've all done the classic question, you know, the famous, like, you know, asking a question too far and things like that. There was an example of that in the trial. It was like, oh, I mean, it was a bit of a masterclass. I know this is horrible. There's a masterclass in what not to do in certain respects. But this was a case, was this a case where this was, you know, was it a good case badly run, or were they doing the best that they could with their client? And I think a little bit. I think it was a mix of both. I think, you know, I've got my standard, here's how to be a good witness, you know, list of things to do and not to do. And Depp's witnesses, they presumably had the same briefing because they ticked all the boxes on what to do and not what to do, whereas it just seemed on the other side that it was like, no, this is just ridiculous. Because you can't coach witnesses, or you shouldn't coach witnesses. But you do need to explain to them how to be a witness. And that just didn't seem to have been done. But of course, you know, you can, with the best will in the world, I've had this. I've told witnesses again and again and said, this is how you need to answer. This is how you need to do. This is, you know, these are all the mistakes witnesses made. And they just go off and once they're in the witness box, they go off and do it. You know, you can only.
It's like setting your team up to play and then they're going to.
Yeah.
They're going to do their own thing in the end of the day. They're going to do their own thing.
Pause there. Now, do you recall that I once said to you, listen to the question and answer the question? You know, sometimes you can get away with just saying that in the middle of it just to try and rein them in a bit.
Yeah.
But yeah, that was, it was, like I say, it was a masterclass in how to present a case and how to be a witness. You know, I mean, Depp's lot were just better witnesses. I'm not saying that they were more credible. I mean, obviously came across more credible. I'm not saying fundamentally better people or anything like that. It's just the fact that they were just better at being witnesses.
I will have to ask the question then. How much, because Amber Heard was the only live trial witness as well as Whitney. How much do you actually think that they actually listened to the lawyers? Because I've noticed this, and it wasn't. I've noticed that when Depp was, I've watched his trial around 4 times. I'm so sad. I've watched his trial like 4 times, all 24 days. I have no life, and I've noticed that.
Well, we had the lockdown. What else to do?
No, but lockdown is over. So, but I was gonna say, when Depp was asked questions, and it seemed like, it seemed really bad. You know what I mean? Like something that anyone would have overshared, overtalked, and tried to defend themselves, etc., because they feel like it's bad. What Depp would do would just say yes.
But that's
yes.
the classic. I always say, concede everything except
because when the lawyers came back up, they didn't really clean up that much. They were just going back to everything.
Shoot their fox, as we say. Basically, just admit you're a terrible human being, and everything they say about you is true, apart from this one thing.
Yeah. So,
and people. I've seen that in so many trials where people have gone, "Yeah, I'm a terrible person. Yeah, I did that." I mean, the classic one we used to do. This is a really good way we used to defend people, actually, which was I've always said, if you're going to set out on a life of crime, do loads of minor crimes and plead guilty to them before you do your big crime. Because the one I always used to say was like, now, let's just clear one thing up here. This is not your first time in court, is it? No. How many previous convictions do you have for burglary? I have 27. Right. On those previous occasions, did you plead guilty or not guilty? I pleaded guilty. Well, why aren't you pleading guilty this time? I didn't do this one. and the number of times that to the jury. The old, I always plead guilty if I did it, and I can prove it by pointing to my criminal record. Juries tend to go, you know what, that sounds pretty plausible. And you can even do now, officer, with my client's terrible previous history, we can understand why you thought he was the guy. Because let's face it usually is, isn't it? And I've actually got police to agree with that. Let's face it, 9 times out of 10, if there's a burglary in this area, it's him, isn't it? Yeah. So he's the obvious suspect. Yeah. And you don't really need to look any further, do you? No. And then it's like, yeah, but on this occasion, you should have done.
How did they not see that coming? That coming? He just walked right into it.
Yeah, but this is it. But, to be honest, experienced police officers, they're brilliant witnesses because they're just so experienced, and they know themselves that trying to sort of cover up. There's nothing more disarming than a witness who's just especially a police officer witness who's just like, I did this, thought it was him, gave him a smack because he's all right. The ones who just come across. I mean, there's a great guy who runs a YouTube now, an ex-police interceptor, and he was saying about why do we always pull particular cars in Bradford, my hometown, and he says, how do we know you're driving without insurance? He says, you're driving a car in Bradford, of course we know you're not insured. That's why we're going to pull you. He says, you can't afford a car this nice. Of course we're going to pull you. He was just being really honest. But you can try and make something with that. But it's that whole thing that people can sniff out when people are being evasive and are embarrassed about a question. And if you just come out and be totally front it and just go, yeah, whatever, yeah. That is a very hard witness to move because you don't have anything to work with other than, well, actually, I suggest that you did do this. It's like, well, no, because if I'd done it, I'd have told you because I've told you everything else.
Yeah. So back to Amber Heard really quickly because we saw Depp's admissions, but when it came to her, I feel like her team told her what to do. I feel like her team just told her, they did tell her what she could admit to, what she couldn't admit to. And I feel like she got on the stand and she was like, I'm going to disregard all of that. And I'm going to... It looks like that. Because she was defending so many things that I'm like, you don't really need to defend that.
And that's the whole thing, making mistakes. All the stuff about the pledge donation, all she needed to say, that was my PR people. There are plans in the pipeline. I've not touched the money. It will get there eventually. But obviously, my PR people just wanted to big me up. And that'd have been the end. That'd have been the end of it. But instead, they gave so much shift
the burden onto the PR. It's not really your fault. Of course, you control them, but end of the day, they have that job to make you look good. So even if you were to be like, no, don't put it out there just yet. Let me do something. It wouldn't matter in the end because end of the day, they still want to put it out there as soon as possible to make you look good.
Yeah, so
she could have been so much.
I shouldn't have said that. Yeah, actually, with hindsight, that was a bit misleading. This is what really happened. That would have been the end of it.
Yeah, but the way that like I don't think but then again, at the same time, when Elaine questions her and she was using the words pledge and donate, watching it the second time and the third time around, I noticed, oh, okay, I can see where she was leading, like trying to create
she's trying to do the best. She's trying to make the best of a bad hand, but the fact is her client really dropped her in it. And that should have been something that was dealt with. They should have said, this is a point they're going to raise, what are you going to say about it? You can't coach your witnesses. And you say, okay, if that's what you're insisting, that's what we've got to go with. But, might it have been that? Literally all she need to say is, look, this is Hollywood. Press releases have no bearing on reality whatsoever. It's all about making us look good. It's all, et cetera, et cetera. Yeah. So that's all irrelevant. Yeah. This is what really happened. Yeah, and it'd have been a non-issue.
Yeah, she could have easily said, yeah, but I did make donations. Like, as you saw in the videos, I did make donations. It was just a bit slow.
She said, yeah, she said, yeah. She said, it's all lined up to give them it. I mean, the money hadn't gone there through, but for, the press people obviously wanted to make it look like it had already gone there because, it's not an exciting story saying it's taking ages to sort the paperwork out.
Okay, so speaking of donations, judging by how Judge Nichols was the one that actually said in his judgment that Depp's defense in regards to the gold digger plea, that it doesn't seem like one's act of a gold digger to donate their money. And when you look in the witness statement, that is what she actually said. She said,
yeah, but this gets to a very technical thing about the appeal, because he says basically she's not a gold digger because she donated the money. Now, here's what's interesting. When they went for permission to appeal, don't forget they never actually appealed this. They just sought permission to appeal from 2 judges. And they wanted to make a point about this, but the trouble is they had made a tactical decision not to actually challenge that evidence in the UK trial. They didn't do you didn't donate this. They just put the question to her and she said no, and then they left it. They didn't bring in any, we can prove that you didn't donate it. Now, I can see why they did that because of the disclosure and a tactical thing. But the rule in an appeal is you can only rely on a point if it's new evidence. Because they'd had that chance in the trial to put that point, you can only rely on new evidence in a trial if it wasn't reasonable for you to actually have raised that point initially. Yeah. The 3-part test, it's like, is this genuinely new evidence? Is it inherently credible? Might have made a difference. And they failed at the first instance because they said, this isn't a new point. You could have chosen to put that point and produce this evidence. You could have gone out and got a statement from the charity saying we never got the money. You tactically, and they said, we understand why tactically you chose to do that. Makes perfect sense. But the fact is, you tactically chose to do that, so it's too late to raise it now. Oh. So that's a really boring technical ground for why they weren't able to challenge that.
Oh, okay. So I was asking the question, not mainly the appeal, but I think when I read it and most people read it, like he knew that he wasn't gonna stand a chance with that one. But I was asking the question more of how much more does the UK judgment look in a bit shaky, considering the judge went out of his way to kind of...
People have their own views on that. I think for anybody who's interested in this trial, I mean, most people probably aren't. It was in the newspapers for a while. I don't think a lot of people go. But yeah, I mean, we have an inconsistent decision. We have 2 inconsistent decisions. But my argument has always been, this whole point that reasonable people can come. I think that decision, it was open to Nichols. He made certain decisions about admissibility of evidence. I think they were all, other judges may well have made different decisions, but they were decisions a judge was entitled to make. And he came to a conclusion about credibility of witnesses.
Yeah.
And the ultimate thing that we don't interfere with judges. I think it's just luck of the draw. I think with a different judge, there might well have been a different result. But I'm one of the people who's not actually going, they should retire, it's a big conspiracy and things like that. He came
No, that's not why I'm asking this question.
Oh no. I'm sorry. I'm not suggesting you. I'm not suggesting
it's fine.
You're very good and you're like very objective about this. And I think, but some people, they're perhaps less objective. They have their own. So some people are going, I mean, don't get me wrong. I know a lot of people have commented about actually. while it was a decision he was entitled to come to, he made some very weird decisions in terms of assessing the evidence, and perhaps. But, this is not uncommon for judges to do a broad brush approach and go, I believe that person over that person. Now, how do I rationalise that? No, seriously, it's something judges do.
I do find it really hard. Let's be honest. I think you got to look at it in terms of writing a story. You always, I don't know, maybe it's my own style, but if I was to write like a script, I always think of the end and then work backwards. Maybe that's my own style.
That's how we do advocacy. We start with what we want the end to be and work back from that. With judges, I mean, Denning was famous for this. Denning was always right. Who do I think should win this case? Right now, what do I need to say in my judgment that makes it look like I've actually used some law in this rather than just gone with who I like? I'm not suggesting that Nichols was doing that consciously or anything like that. Nichols is a really experienced, good judge. And I just think it's one of these things where, it was entirely open to him to say, I don't really care. I just prefer the evidence of that person over that person.
Yeah, I do.
But that's what maybe juries are a better system, because juries average that out. And you might say, well, hang on a minute, I'm not sure about that. I think that person might be telling the truth.
The way that both cases were adjudicated, the approach to all of it and everything, you watching this case as just a UK lawyer, what were your thoughts in regards to the final judgment that was handed down, juxtaposed to the UK judgment?
I think it was a judgment. It was a decision the jury were entitled to come to on the evidence. I think that's, I can certainly say that, I'm not sort of going, I've, never expressed an opinion as to where I think the truth lay or anything like that, because about anything else, it's not my job and nobody cares. But I think the trial was conducted properly. I think the judge was very, very good.
Very lawyer answer.
I mean, that was it. People have said criticise the judge. There was nothing to criticise about the judge. It's very
I'm actually with you on this one, because I read this. I read the Criminal Act, and I thought he was using that. Then my friend sent me the civil 1995. I forgot the name of the act, but it's 1995.
Evidence Act 1995.
That's the one.
I was really cool because I was at law school when that came in, so it was great because it read everything really cool.
Yeah, so I read that and I was like, oh wow, he could have. He actually, everything that he did was actually by the law, so he wasn't prejudiced inherently, so to speak.
I mean, that's the thing. I'm unique, possibly, well, maybe with Dan as well, in that I have said, with regards to the England and Wales thing, that was a decision the judge was entitled to come to, and that was a decision the appeal bench were entitled to come to. But I say it's the same thing about the VA trial. That was the decision that the jury were perfectly entitled to come to. So there you go. So I'm just saying, everybody's right.
Everyone is right. No one got it wrong. Yeah. But I was what was it? There was one decision that I didn't agree with him on, and that was the police. And this is the part that I'm like, maybe this was the wrong forum for this case, because I do understand that in the UK there's a lot of reliance on contemporaneous evidence, like when you're there. Over here we do have a rule that no, even if nothing happened, even if it's a rule that really slips down to almost every part of public service. Can I say that? Public service? Yeah, because I used to be, I don't want to bait, I think I used to be a civil enforcement officer, and we even have this rule.
I didn't know that, but there you go. So you are more than, so this is why you know all about pace and everything. So this is all your bread and butter stuff. You'll know all about pace and all that sort of thing.
Wait, sorry, I didn't quite hear that. I know about what?
No, pace and Police and Criminal Evidence Act and all the rules.
We had to be put. Yeah, because apparently, well, they were telling us on training that if something was to happen right there and there, we would technically be the eyes and ears of the police at that moment, and we have to write down
the video. Check out my hostile witness video, because that is exactly on this and about the taking contemporaneous notes. All professional people like yourself know to do that, because then they can actually have that in the witness box with them.
Absolutely. So that's why we had like every time we had a pocketbook, and that was where it would all go into, and that was, anyway, point was, point was the judge actually said what the judge was saying around the police taking the evidence for the 21st of May. I was like, I know this is what we do in the UK. I'm like, this is where I feel is, I wouldn't say bias, that's the wrong word to use, but it's knowledge.
Something that gels with your own experience. And this is why I think juries are great, because juries have more experience. And somebody go, well, actually, yeah, that sounds very familiar. You know, that makes perfect sense to me because I've been in that position. So I think that's why, yeah. Oh, but there you go. You see, you know more about this than I do.
Yeah, so no. It's because I was thinking, because if this was in a jury trial and I was there, if the police were telling me, oh, we're not actually required to, you know, write down notes on the day, we only do it when they do an incident, I wouldn't think more of it. I'll be like, okay, that's their rules. But over here, because he's got that.
But you knowing that, you go, well, hang on a second, because even if you just like attended no further action, you would have made a note of it, yeah.
Yeah. You know, but like, you know, so you can see how the judge, this is where I kind of felt sorry for him, because I'm like, I understand where you're coming from, because how does a public official like not at least make some kind of note? So just something. But that's the bias of living here for so long and, you know, knowing how this side works, because over here, I would like, you know, if I was him, I'll be thinking the exact same thing. I'll be like, but you're the police.
Yeah.
You went there. Like, even if nothing happened, just, you know.
Your level of detailed knowledge of both these cases is really impressive. You're remembering all the facts, all the days. This was like, you know, this was a year ago. So as far as I'm concerned, this was, I've been being in like the Neolithic.
Thank you.
I can't remember what I did yesterday. So I'm really impressed with your knowledge of this. I say this because people also like writing attendance notes on cases. And people said, you've got to write them as soon as you can. I said, I literally have to write them as soon as the case finished. Otherwise, I couldn't remember what I'd done that day. If I sort of went, I'll do it when I get home in the evening, I'd be sat there going, where was I today? And I'd be pulling the papers out going, oh, yeah, right, yeah, I was doing that case, wasn't I?
No, anyways, I appreciate that compliment. I thank you so much.
No, it's very true. I'm very impressed with your level of attention to detail. That's the thing, because everybody can have their own opinions, but you can't have your own facts. And so many people are getting the facts wrong. Oh, this was done, this wasn't allowed. No. So that's what we built.
I appreciate you for sitting down with me. Thank you so much, man.
This has been great. If you need any follow-up, just give us a shout.
Yeah.
So hopefully you get something out of what I've done. But just give us a shout if you need any more. But if I don't go now, your big story, the lawyer pisses himself.
No worries, man.